All right, good afternoon, everyone, and welcome to our second annual Ask the Benefits Attorney as an installment of our monthly benefits lunch break webinar series. Hope everybody is doing well. Before we get started, let me just cover a few housekeeping items. We did get a series of questions in advance, so for those of you who sent questions in advance, thank you for those. Before we get started, we are planning on continuing this webinar series in 2023 on a monthly basis. Again, we're going to do the third Monday of each month at noon Eastern time. So as you can see here are the upcoming dates in 2023. Again, if you have topics that you'd like us to try to address, please feel free to submit those either through Q&A or when you register. So none of these are essentially planned except for the caveat of it looks like the Secure Act 2.0 is going to pass as part of the omnibus spending bill. If that in fact does happen, we will likely dedicate our January webinar to discussing changes made by that act. And then December 20 of 2023, unless we hear that nobody really likes the Ask the Employee Benefits Attorney webinar anymore, we'll probably plan on ending the year with the same webinar as we're doing now and did last year. All right, so this first one here is for Jeff. Jeff, can you provide guidance on how to handle making changes to the deferral start dates once a plan document has been signed? For example, we set up a plan with a deferral start date of July 1, 2022, but as we approach this date, we know deferrals are not ready and will not begin with the first payroll effective on or shortly after July 1, 2022. Prior to July 1, 2022, can we amend the plan to push out the deferral start date to October 1, 2022 as an example? Assume this is a new plan, so no assets are in the trust yet. What big fact pattern there?
Big fact pattern.
What guidance can you provide us on that one?
Very specific, which is always good. I think the answer is yes. You would want to do something in that case, because if you allow that date to pass by and you're not able to make those deferrals, then you end up having to make some sort of self-correction, potentially to make up the missed contributions and matching contributions, for example. So I think you would want to amend it in advance of that initial date that you picked to potentially delay the start date of those deferrals. I guess the caveats to think about are if this is a safe harbor plan, for example, you have to think about, is this going to be some sort of mid-year plan amendment where we might need a new safe harbor notice, or are we trying to put this new safe harbor plan in place for the first time? In that case, it has to be at least 3 months, so you wouldn't want to push those deferrals out beyond October 1, for example. So I think generally the answer is yes, you could amend the plan, but we'd have to think about the details and specifics at the time.
Perfect. And maybe that's a good time to add a caveat. We're going to be addressing these questions in a very general setting and giving our advice. Certainly, if you have specific questions, feel free to follow up with us directly or consult with your legal counsel, as we recommend that, as some of these questions are pretty specific. With that, we're going to move over to the health and welfare benefit side. And this first question here is for Brett, and I may jump in here too. And the question is, do you see enforcement of the ERISA safe harbor exemptions associated with employers offering voluntary benefits? Now, Brett, before you answer that question, maybe tee it off by kind of explaining what this voluntary benefit exception is from ERISA.
Sure. So in general, many health and welfare benefits are subject to ERISA, but there are some exceptions to that general rule. And one exception is for voluntary plans. So for example, a voluntary life insurance plan may not be subject to ERISA if it can satisfy 4 different requirements that apply. And first, the employer must not make any employer contributions. All of the contributions must be made by employees. And employee participation in the plan must be completely voluntary. And third, and this is the big one, the employer must not be involved with or endorse the voluntary plan. So the employer must basically take a hands-off approach to these voluntary plans. And then last, the employer must not receive any form of compensation from the insurer of these voluntary benefits.
And how about the enforcement these types of benefits? Do we see the IRS, or I'm sorry, the Department of Labor questioning employers' designations of certain benefits as voluntary?
So in my practice, I have not seen significant enforcement activity, but it's still important that if a plan is subject to ERISA, it will still satisfy ERISA's requirements, even if there's not a lot of enforcement activity.
Yeah, and I'll point out a few things. This voluntary exception is kind of migrated with how it applies and how I guess the insurance market has changed over the years. I think when this first came out, it was really, hey, I'm just letting random agents come into my, company break room at lunch and kind of promote, products they're selling to my employees. And maybe I'll even go so far as, if they sign up for a product, I'll agree to withhold the premiums from the employee's pay when they sign an authorization and remit those. So that's really the nature of that practice has changed. And I want to point that out because a lot of times it would say, just for the employer to take a hands off, the employer should not be choosing the insurer. Well, now we have a lot of worksite related benefits where, employers take the position that they are voluntary benefits, but they are really subject to this exemption from ERISA, but they are really a little bit more involved in picking the insurer, whether that be an AFLAC type, benefit or whatnot. And again, we haven't seen a lot of enforcement activity there. With one caveat, keep in mind that some of the insurers will put in the documents that they have that, a statement of ERISA rights. And it's hard to say, it's hard for an employer then if the documents portray that these voluntary benefits are subject to ERISA, that they're not. So you want to review the documents to make sure there's no references to ERISA. Many times the insurers like to be subject to ERISA because some of the beneficial requirements they get in both the claimant appeals and then if benefit denials are litigated. But again, bottom line is this is not seeming to be a hot topic area for the Department of Labor enforcement. We're going to go over to a couple retirement type questions for Frank. He has got another commitment, so we're going to try to get through his portion relatively quickly. And that also means if you have any questions you haven't submitted yet that you want Frank to answer, now is your time. So with that first is historically a balanced portfolio with 70% stock and 30% bonds with fixed monthly contributions is a good strategy. With the current economy, both stocks and bonds are down significantly in 2022. I suppose it goes on. Is that still a good strategy? And with the caveat that Frank is a lawyer, not an investment advisor, but I'm sure he has some input and he can get down this.
Yeah, so there certainly was no question with this, but certainly it appears that somebody was thinking about the fact that the strategy makes sense. And obviously it would have been much better to ask that question a year ago when they were trying to do something about it. But I think what's become clear is the vast majority of investors didn't understand the distinction between bonds and bond and mutual funds. And because everybody kind of thinks, well, they're bonds, they're going to pay me this percentage. How can they go down in value? Well, a bond fund can go down a lot in value, as people have learned this year. And a lot of people were expecting this year that we would have something like this because interest rates rose, which caused stocks to go down, but it also caused bond values to go down if they were sold. So a bond mutual fund that's holding a bond that's paying 2% interest, and now interest rates go to 4%. Well, if you own the bond yourself and you hold it to maturity, you don't take a loss. You're earning, less interest, a lower amount than you would have earned if you had not invested in that, because it could have gone to 4%. But if you're in a bond mutual fund, people are redeeming those and investing in things that are earning higher rate, which causes a loss in the fund. So that's the big flaw that people have discovered with bond funds. And it's a flaw that exists then in target date retirement funds, because those have predominantly been a mix like this, 70-30, depending on how old you are, more heavily in bonds and less heavily in stocks. But those have traditionally been almost exclusively equities and bond mutual funds. I think what people are now realizing is that a better alternative is, first of all, a mix of other alternative assets, real estate, commodities, managed futures, things that are not as correlated with stocks and bonds, even though stocks and bonds aren't always correlated, this year they definitely were because interest rates were starting at such a low level. There's no way bonds could really go up when interest rates are starting almost zero, as they have in some years in the past. When stocks have gone down, bonds have done well because interest rates have dropped. Well, when starting from a zero interest rate or almost, they can't really drop any further. So people, I think, have learned that flaw in the target date funds. But they also have learned that a target date fund is a pretty good accumulation vehicle in retirement or for retirement. But once you get to retirement and you have to start taking distributions, it by itself is not a great vehicle. And that is because of the fact that you have a year like this, where if all your retirement money is in a target date fund, you're forced to sell out at a time when they are both down. So you're taking the loss. Whereas if you went to a strategy that if you're using multiple funds or you're buying individual bonds, or you have the bucket approach where you have, say, 80% of your money in the target date fund and you have another 20% or some percentage in very fixed return assets that are very short term, money market fund, something that's no more than a 1 year CD or treasury. That way you can live off of that money for several years until the assets in the target date fund recover. So I don't think that's been widely understood, and it didn't need to be until this year. The target date strategy had worked well for a number of years when both stocks and bonds performed well, or they didn't both perform poorly at the same time. This was a good learning lesson year. And hopefully plans are now looking at broadening their target date fund exposure to other types of assets, and also educating their participants about how to use those funds appropriately if they're going to keep them in the plan.
Thank you, Frank. I guess a somewhat similar related question to follow up is, what tax and investment strategies or plans are you recommending to maintain value in your investments and protect cash flow for retirement?
Well, certainly from the tax side, you're really looking at doing two things. Number one, everybody should be deferring as much as possible. Take advantage of your qualified retirement plans. Because I think really before this year, there were more and more people that were thinking they have money saved for retirement. And now after this past year, they're not thinking that so much. So it's always good to have more than you think, because a downturn can occur at any time. And right now, we have no idea how long this downturn is going to last. That's one of the other things that people have really been educated about this year, is the last couple of downturns we've had in the market were very short. The COVID one, it was like a month or two where the stocks went down 30% and then they bounced right back up. That's not guaranteed to happen right now. It's possible that we'll recover these losses next year. It's possible it won't be for 5 years. So save as much as possible. Take advantage of Roth, whether it's contributions right now or Roth conversions. So you're not having all of your money that's going to be taxed at a later time. You might want to have some of it taxed now, and so that it's tax-free later. So those are the tax strategies, really. And the investment strategies are also looking at possibly offering things like annuities within your retirement plan, some type of lifetime income options, so that there's always going to be some people that like that comfort of knowing, okay, maybe I won't earn these great returns that we have earned in retirement plans, at least in the past 20 years, but I'm covered. Things can't drop so bad that I lose all of my money. And certainly others that may not like that strategy, but are willing to put a portion of it into some kind of lifetime. So that's the part, I think, of retirement plans that has not been addressed adequately yet. It's all been about the accumulation phase, not so much the distribution phase. And as we know, as people are living longer, a lot of times the distribution period is longer than the accumulation period was. So it's definitely something that needs to be addressed by plan funds.
Thank you, Frank. And one more, at least pre-submitted question for you, and this is a little bit broad. So I realize you're probably going to give it, the 10,000-foot view approach, but explain the different ways in which ERISA impacts benefits. Specifically, what key items do employers need to be aware of as it relates to executive compensation?
So this is a great question because I have had a number of things that I've discovered that certain clients did incorrectly in the last few months. So this is a good time to be addressing that. So if you don't have a qualified retirement plan, if you don't have a 401A, 401K, 403B plan, you're in the non-qualified world of providing executive compensation. So those plans are still subject to ERISA. And that's important to understand because that comes along with things like, even though you generally don't have to file a Form 5500 each year, there is a one-time filing that has to be done with the Department of Labor. And if that's not done, then there is a Form 5500 filing requirement. And obviously the penalties can be significant if that's not filed. So that's one of the things that ERISA, one of the implications that ERISA has. But the others are that you basically have to have an appeals procedure and follow a few of the other procedural things under ERISA as far as where lawsuits can be filed and things like that. But mostly they are exempt from ERISA. And that is because they are limited to a select group of management or highly compensated employees, what they refer to as the top hat group. But the key thing is to understand is that if it doesn't meet that exception, and that exception, unfortunately, is not well defined. The Department of Labor has not issued anything, and I mean anything, in probably 20 years on that issue. There are some old rulings that discussed it, and generally it means more than what the IRS considers a highly compensated employee. These need to be people that can kind of protect themselves. They don't need ERISA's protection because they can negotiate their contracts and things. So if you meet that top hat group rule, then the plan's exempt from participation and funding and coverage requirements of ERISA, vesting requirements of ERISA. If you don't satisfy that, you're subject to all of those things. And that's where I've seen some clients lately that have gone way broader than what the top hat group would be in covering people providing deferred compensation. And remember, deferred compensation is really anything that promises a payment in the future that is currently vested. So if you have a bonus program or something that says, well, if you stay here for 3 years and you do this and this, you'll get paid this amount at that time. That's not really one of these programs because it vests and gets paid at the same time. But if you say, if you do this, we're going to pay you this amount 5 years from now, that is deferred compensation and has to satisfy this exemption, or else it's subject to all of ERISA's vesting and other requirements. So one thing to understand is governments are exempt from ERISA, but tax-exempt non-governmental entities are not. And one of the things that I've seen recently is a 457B plan for a tax-exempt employer that was covering all their employees. That's not permitted. It's an ERISA violation. It generates potential penalties from the Department of Labor, and in addition, grants those participants some rights that they shouldn't have had and might be very expensive to the employer. So it's a great question. Be very aware of any types of deferred compensation you're providing. It should be limited to a select group, but even if it is, there are things that have to be complied with.
Thank you. And that was a good primer. And actually, also to be aware of, it didn't even touch on many complexities we have in the Internal Revenue Code, taxation for compensation. So we won't jump into that, but keep in mind there's a plethora of tax considerations you have to keep in mind when implementing an executive comp or deferred compensation plan. Next, I will be handling this question. It's on the health and welfare side. If we wanted to switch our open enrollment period, for example, from August to December, and our plan year from a 9/1 to 8/31 to a calendar year, how would that work? Would we just have a year in which we had 2 open enrollment periods, one in August and then in December, in a short plan year from 4 months from September to December? And I guess the answer is yeah, essentially that's what you would do. I mean, and it is permissible. You do need to have a bona fide business purpose under Section 125 of the Internal Revenue Code for switching your plan year. But that's loosely defined, and I've had several clients do it in the past. So essentially, you would have a short plan year because you cannot have a plan year under 125 that's longer than 12 months. So presumably, it would be from 9/1 through the end of the year. How you handle enrollment is really up to you, and there's some flexibility. You do need to have 2 open enrollment periods, but oftentimes what employers will do is we'll have one robust open enrollment period where, kind of what they're used to. There's a big marketing campaign, you go in there, you require affirmative enrollments. But for the second enrollment that may take place either shortly before your more robust enrollment or shortly after, you have what I refer to as a passive enrollment, which we do give people the opportunity to make benefit election changes if they want, but we basically say, it's passive or soft and say, hey, we're not going to advertise as much. If you want to make elections, here's your time to do that. But if you don't make any election changes, all of your current elections will stay in place for the next plan year. Keep in mind that if you are an applicable large employer subject to this ACA employer mandate, which is the requirement of the ACA that certain large employers offer their full-time employees health insurance that's both minimum value and affordable, or pay a non-deductible excise tax, and you use what's called the look-back measurement method for determining who are your full-time employees, it gets a little bit more complicated because we have to shift those measurement and stability periods. And essentially, you're going to be measuring people for a certain period of time under the old periods and under the new periods. And you're going to give them the benefit of the doubt. If they hit a full-time status under either one of the old or the new, you're going to treat them as a full-time employee. Again, that's very fact-specific and can get complicated very quickly, but keep that in mind. Finally, the last thing is keep in mind how that's going to impact your Form 5500 filings. That's going to change the period on which those are due, which is typically 7 months after the end of the plan year, but can be extended for another 2.5 months. So that is, if you change the plan year, that's going to change the deadlines, both unextended and extended for the 5500. Next question, we're going to move back into retirement, throw this back over to Jeff. Is the executive team typically removed from COLA, cost of living adjustment increases, if they do not have a different bonus structure than the staff? And then a slight variation is, what if they do have a different bonus structure from the staff?
So that's an interesting question. I guess I'd just say, first off, as a private employer, that's up to the employer to decide. And I don't believe that most of my clients that I work with typically have compensation that's directly tied to some sort of cost of living adjustment every year. I think I saw a SHRM study that said something around 11% of employers actually do that, really have their compensation wage schedule kind of directly tied to some sort of COLA adjustment or adjustment for inflation. I think more often it's some combination of company performance, personal performance, merit, service, any number of things that could go into someone's pay increases. So I think that'd be a good question for the compensation consultant or nurse or something along those lines.
Thank you, Jeff. All right, so next we're going to kick it over to Brett Swearingen, and we've got several questions on Michigan's ESTA and changes that we're looking at. I don't know, Brett, do you want me to read through these questions, or you just kind of want to address these questions more generically? I know that right now our labor and employment section is meeting, and one of the agenda items on this is discussing. So I think I don't want to speak out of place here, Brett, but this is something that you guys are on top of. And as developments come, we're going to push out guidance. But let me know if you want me to read any of these questions directly, or if you just want to kind of address what's going on and what our thoughts are on this right now.
Yeah, I can do the big picture and then just address the okay. Specifics. I think that's not too hard. So yeah, this is a big issue for employers, and this is a question that straddles employment law and benefits law, and thankfully that's what my practice does too. So I do want to back up and give the big picture. I will try not to be too convoluted because it is a little complex of a backstory. So the questions that I'm going to talk about are the Earned Sick Time Act, ESTA, which was part of ballot initiatives originally under the state constitution in 2018 there was both a paid sick time component of these ballot initiatives and there was a minimum wage increase component. If you paid attention to what's been going on in the employment space, these have been big topics, but they were part of a ballot initiative in 2018. The Michigan legislature in the fall of 2018 jumped the gun before they were actually voted on and passed the actual language from the ballot initiative. This was the Earned Sick Time Act and the minimum wage increase. A few months later, after the election, after the November election in 2018, the legislature amended the ballot initiative language in a pro-employer direction. And that amendment was challenged legally under the state constitution as unlawful. For a variety of reasons, it took a while before that worked through the state judicial process. But this past summer in July, a judge ruled that the Michigan legislature could not have done that. It was a violation of the Constitution. And therefore, the original laws were reinstated. Shortly after that decision, the judge ruled, thankfully for state employers, that the effective date of these laws would be stayed until February 20th, 2023. Now, litigation continuing to challenge whether this is the right call under the state constitution is continuing. There was actually a oral argument in the case at the Court of Appeals just last week. And both parties are hoping and requested on the record that the judge in this case at the Court of Appeals issue a decision before February 1st so that employers are not left in the lurch. But as it stands today, if nothing else changes, I should say another thing that could happen is the new legislature that will be convening in January could fix this problem, if you will, on their own by just passing a law that phases out the increases or does whatever they want, frankly. But as we stand now, it's planned that on February 20th, all employers in the state will be needing to comply with the Michigan Earned Sick Time Act, ESTA. And as Tripp said, we are here at Miller Johnson, the employment section is all over this. And absolutely, as developments come down, if there is an extension of the stay, if the judge overturns the lower court's ruling, we will be making sure to push guidance out to our clients as soon as we possibly can. Let me address I think there were two specific questions about the Earned Sick Time Act, again, which will be going into effect absent anything intervening on February 20th. The first question was, if we want to use our existing PTO policy to satisfy the Earned Sick Time Act requirement, which requires at least 72 hours of earned sick time per year. For example, let's say an employee receives 80 hours of paid time off and they choose to use 40 hours for vacation and then do not have 72 hours available for sick time. Is that okay? That would not be okay. The law is clear that whatever you want to call the paid leave, an employee must receive at least 72 hours of paid leave, assuming that they accrue that much under the law. The law says that an employee must accrue at least 1 hour of paid sick leave per 30 hours worked. But the law also caps the maximum amount of entitlement to 72 hours per year. So it's certainly fine to have a kind of combined paid time off policy that covers vacation and sick leave, but you must make sure that within that policy, an employee has access to at least 72 hours of paid sick time in that year. Again, assuming that under their hours worked, they have accrued that much. The second, actually, there was, I think, 3 specific questions. Oh, so the second question is kind of the same thing. You can use a PTO policy. You just have to make sure that separately from that, you have the 72 hours of sick time, regardless of whether the PTO has been used by vacation. You still need that 72 hours. Okay. The last question is about, can an employer, as I understand it, can you give employees sick time sooner in the year than they would earn if they accrued it at the 1 hour per 30 hours work rate? Yes, you absolutely can. That's called front loading. The law does not address this per se, but there's nothing in the law that says you can't, as long as the employee is able to take the entitled leave that they earn under the law. It doesn't matter if the employer gives that, on January 1st, or in this case, say February 20th, and then lets them use it from there. So yes, that is certainly lawful under the Act, and probably more administratively feasible for the employer. I think that's it.
Thanks, Brett. That's very helpful. And I know that a lot of employers are are worried about what's going to happen with this. So thank you, and we appreciate you guys being on top of this. Switch it back to a little bit of health and welfare. We're going to involve Alex here. HSA forms or HSA pre-tax elections, so employee contribution, pre-tax contributions to an HSA, have to be refilled out every tax calendar year, even if the employee has no changes. What do you say about that, Alex?
Yeah, so the simple answer here is no, nothing in the law requires that these HSA elections be resubmitted every year. That's a choice that's left up to you as a private employer. You can choose to allow that to happen every year or choose to allow those elections to carry over year to year. One caveat here that should be noted, though, is the fact that you as an employer are required, at least on a monthly basis, to provide your employees with the option to stop, resume, or change their HSA elections. However, most employers allow an employee to do this at any time during the year, so long as they submit a request to the employer.
So yeah, so you can absolutely, you have a lot of flexibility here, to carry over an individual's pre-tax HSA contributions from one year to the next. You can either carry it over, you can make them re-elect. The only rule is here that they have to be able to change those HSA contributions at least once a month. But in my experience, most employers allow those changes to be made at any time respectively. Do you want to address this follow-up question? Okay, we got one follow-up question about the Michigan ESTA that I'll let Brett jump back into.
Yeah, Elizabeth, you submitted a question about saying the other attorneys are saying you cannot front load the ESTA leave. I have to be candid. I see that guidance. I see other attorneys saying that too on the internet, and I don't know why they're saying that. I've looked at the law, the text of the law itself. It does not exclude front loading the leave. It does not say you can, but I don't see any reason, just because it's not explicitly authorized, that there's something that prohibits an employer from being more generous. Again, so long as the accrued leave that the employees are allowed to earn under the law is granted. So again, I've seen what you're seeing, and I honestly don't understand it, and I do disagree with that advice. I think the law is clear that an employer who front loads a leave is under the law. And I'm happy to answer more questions if you'd like to contact me directly, or I can put you in touch with some of our other in-house experts on the paid leave question. But thank you for the follow-up.
We'll keep it in your court, but shifting gear to FMLA. So we got an FMLA question, not related to benefits. So it says, we teeter on 49 to 50 employees during the year. We do a look back for an average to see if we have to provide FMLA. The result might be having FMLA at the beginning of the year, but not 6 months later. What is the best way to handle this so we don't have to rewrite policies or addendums to handle this?
Thanks, Trip. So this is a common type of question that we get from our mid-sized clients. And I do on the front end want to encourage clients who have a kind of very specific fact question to reach out to me, or I would say our other in-house FMLA experts are Sandy, Andre, and Sarah Willie. Because the details can really matter here. But let me lay out the gist of what the FMLA regulations state. And I think this particular question has a little bit of a misunderstanding of what the law requires. The law says that you are covered by FMLA if for at least 20 weeks of a year you have 50 or more employees. And they count that as generously as possible. If an employee works at any part of a week, you count that employee for working for that week. So the critical question is for any 20 weeks of a year, doesn't have to be consecutive 20 weeks, do you have 50 employees working for you? If so, you are triggered as of that date, the 20th week, you are triggered as being under the law for both that current year and the next year. So that you don't honestly, you need to worry about whether you've hit that trigger, but you're not going to be teetering back and forth. If you've hit that trigger, you know that for the rest of that year and for the next future year, you are under the FMLA. So I think Congress sort of saw that possible problem and tried to give some stability to employers that may be hovering around that 50 employee mark. And again, if you have further questions, because again, this is going to be very detail specific, please reach out to me or one of my colleagues. Thank you.
So you're not going to go in and out of being subject to FMLA
Once you're
during
in,
the year.
you're in for at least that year and the next year.
So, okay. So you can come into it mid-year, like for example, after 20 weeks. But if you come into being subject to FMLA, you're locked in for that year next year. You're not going to necessarily fall back out during that.
That's correct.
Okay. All right, next question. We'll go back to Alex. What is the best publication to reference for when company vehicles, such as service vans, not executive type cars, are a taxable fringe benefit?
Sure, and this is a good question, and luckily one where we can point to a single IRS publication and not several and have you piece them together. So I would say the best publication to reference for employer-provided vehicles as a fringe benefit is IRS publication 5137.
Which you can find by just Googling pretty easily.
Right, and specifically pages 36 to 43 of this publication provide details on the taxability or excludability of employer-provided vehicles. Just as a general background, I would say that if the vehicle is owned or leased by you as the employer and like a service van being provided just during the workday for business purposes, that use will generally be excludable as a work condition fringe benefit under Section 132. But as always, there are exceptions to this rule. So if you'd like to discuss specific situations related to excludable fringe benefits, such as these employer provided vehicles, you can feel free to contact our practice group and we can go through the issues one by one. Yeah.
Well, I think the biggest probably difference here between a service van is even if it's a service van that people are taking home and parking at their home at night, really generally only being used for business purposes like making service calls, where if you have an executive type car, you have the executive that's probably using that car not only for business purposes, but they're probably not, probably using that car for their own personal purposes too. They may not have their own personal car. So obviously we have some tax components that apply to the personal use of a company provided car, which again is usually different from a service van. You're typically not driving around. You're not allowed to drive service vans around for your own personal use, even if you are, for example, taking it home. Next, we'll go back to the retirement side, coming back to Jeff. How often do 403B plans need to be restated if the employer is not making any changes to the plan? For example, say the plan was last updated and reviewed by Miller Johnson in 2009.
So 403B plans are similar 401k plans in some respects. With a 403B plan, you might have an individually designed plan, or you might have a pre-approved plan. A pre-approved plan is something that's prepared by, for example, Miller Johnson. We have a pre-approved plan document, but we also have some clients that are on an individually designed plan. The pre-approved plans are on a 6-year cycle that's similar to the cycle that applies to 401k plans.
Offset though, it's not running on the same cycle.
Correct, it's offset, and so that restatement deadline is coming up here not for a number of years. We restated these plans in 2020. That was the most recent date that pre-approved plans have been restated. The deadline for us to submit our next kind of pre-approved plan document to the IRS is next May. The IRS will review all of those documents that they get in over the next year or so. And then we anticipate that employers will need to then sign those updated pre-approved 403B plans in 2025 to 2026. We usually have about a 1-year window. So we think that's the next time that you'll need to actually sign an updated and restated pre-approved 403B plan. All of the 403B plans though needed to be restated in 2020. So if you have a 403B plan document back in 2009, you should contact either me or Frank, and we can kind of sort out where that stands and whether that needs to be updated or not. If you have individually designed plans, those don't have a formal restatement deadline. They just need to be amended for changes in the law. So
there are deadlines for those amendments have to be adopted.
There are absolutely deadlines for when those have to be adopted. It's generally at the end of the second calendar year that follows the year in which the IRS announces the change in its required amendments list. So you will have repeated amendments for those plans. We would have had CARES Act and Secure Act amendments for those for 403B plans generally this year, but the IRS moved that deadline to 2025. So these plans do need to be amended fairly regularly, and the pre-approved plans do need to be restated every 6 years. So it's a good question, and reach out to us if you have any other questions.
Well, and while you have additional time to adopt some of these CARES Act and Secure 1.0, and sometimes if you're able to do it quicker, there's some sense to that, right? Because by the time I think sometimes if you wait too long, you can forget what changes you actually made. Specifically with respect to the CARES Act, that had some very temporary changes, in order to respond to the COVID-19 pandemic with respect to additional reasons you could take hardship withdrawals and additional amounts and whatnot. And for many 3 or 4 years, 5 years after that, what did we do back then? Or I wasn't even here back then when we made those changes.
Yeah, it's kind of a mixed bag. I mean, the CARES Act specifically makes sense to amend sooner rather than later because the changes that you made for the CARES Act. The Secure Act, though, that one, we were amending to change the required beginning date, which sounds like it'll be amended by Congress again here soon. So there's so much in flux with that. It's almost tempting to just wait until Congress and the IRS get their story straight on what the required beginning date will be going forward. The other thing to mention, don't forget if you have just operational changes to the plan. That wasn't in the fact pattern. If you have operational changes to the plan, you've got to impact that plan by the end of the year as well. Governmental employers, I should say, also have different deadlines than what I've talked about. They have a little bit more time potentially depending on how often their legislative body meets. So keep that in mind too.
All right. Well, I will finish out the webinar with a few last minute health and welfare questions. And then one other thing that I want to let employers know while we have your ear. So here's a question. If we have reminded new hires multiple times through multiple methods, self-service HRIS, work and personal email, phone call or text, then email, mail, and no response of only employer paid benefits to complete their benefit enrollment through our self-service HRS and they do not respond, what is our responsibility for proof of offering coverage? Do we need to continue to follow up until we get an acknowledgement of a signed waiver of benefits? How much follow-up should we do and show that we've offered benefits? So really, there is no requirement that you have any evidence to show that you offered benefits, with one caveat. If you are, again, one of these applicable large employers that's subject to the ACA employer mandate, you do have to make an offer of coverage to your full-time employees. The employees don't need to accept it, but the question is do you need to substantiate your offer of coverage? Well, clearly, if you have a signed declination or a signed waiver of coverage, that's good. And if the IRS ever challenges whether you offered a certain full-time employee health insurance, if we have that, that goes a long way. However, our office has helped a number of clients, I would say north of 200, respond to these proposed assessments of the employer pay or play penalty. And generally, the IRS has been very willing to accept an authorized officer's statements as to what happened without requiring any additional documentation. So again, there's no legal requirements that you prove or have evidence of offering benefits for purposes of the ACA employer. It certainly provides you an extra level of protection if the IRS were challenged, whether you actually did make the offer to someone, particularly if they waived. That hasn't seemed to be necessary now, but the IRS starts actually auditing compliance with this versus just sending letters and accepting responses back, that may be helpful in the future. We also got a specific question with respect to the MEPSR system, which is the Michigan Public School Employees Retirement System. Particularly, and I'm going to go to a slide here. Jeff, can you put this PowerPoint back on? With how long after someone retires from a school district and is receiving retiree health care or receiving pension benefits from the state, how long do you have to wait before you can be rehired? These rules recently changed. Now, if you have a bona fide termination and you rehired past 9 months, you can work for school districts with no earnings limit, so you can make as much as much as they're willing to pay you. And that will not adversely affect either your pension benefits or your retiree healthcare contributions. Previously, if you're going to return before 9 months, I still think there's exceptions. For example, if you're returning to what they call a critical shortage area, But up here on the screen, I put a link as well as a screenshot of FAQs to this new law that changed the period in which you can return to work to 9 months without any penalty or earnings limits. So I would encourage the individual who submitted this question to take a look at those FAQs for further guidance. Finally, one other package that's part of the omnibus spending bill. For those of you that have high deductible health plans and HSAs and also offer a telehealth benefit, you may remember that during COVID, because telehealth became much more valuable, with the fact that we couldn't do in-person care for a lot of things, the IRS said, hey, you can offer your HSA eligible folks a telehealth benefit without jeopardizing their HSA eligibility, but that was temporary relief, which ended at the end of 2001. And then in 2020, Congress passed a law that extended that rule, but only beginning April 1 and lasting until the end of this year. So oddly, we had January, February, and March of 2022, where if we offered the telehealth benefit to HSA eligible folks, we could potentially jeopardize their HSA eligibility. That extension of the previous relief, I think, under the CARES Act, began again April 1 of 2022 and is scheduled to end. If the spending bill passes, this relief is going to be extended for 2 more years, so it will apply both in 2023 and 2024. Again, scheduled to end for 2025. I wouldn't be surprised if it's ended again, and it would be very helpful if they would just make this permanent. So again, that hasn't been passed yet, but we suspect that it will. So wanted to give you a heads up on there. Otherwise, there's not a lot of, unlike back in December of 2020, where the Consolidated Appropriations Act 2021, this new omnibus spending bill does not have a lot of implications for employer-sponsored health plans. We got one follow-up question submitted. If currently the company does not have auto-enrollment, is changing the trustee considered changing a grandfathered plan, and will you need to do auto-enrollment per the new legislation? So I've been thinking that this is a health plan because they're talking about a grandfathered plan.
I think she might be talking about the auto enrollment requirement under
the auto enrollment. There was an auto enrollment requirement under the ACA for health plans that was rescinded, so there's no auto enrollment. And I guess changing the trustee, generally we don't have trustees. Yeah, but I'm not sure how a grandfather plan applies to 401k plans.
Well, I think she's talking about under Secure 2.0, there's this requirement of adding auto enrollment to new plans. And the question is, so you don't have to do that if you already have a plan that doesn't have auto enrollment.
Oh, it is for 401k. Thank you for that follow-up.
Yeah, so I think the question is, does that change in trustee kind of create a sort of new plan to the extent that you have to add auto enrollment? I think the answer to that is no. I've never read any commentary on the early versions of this legislation that would suggest that just changing trustees would cause you to need to add auto enrollment. But I will say, so this legislation, I think we got a copy of it a couple days ago. It's about 400 pages. We're making our way through it. In January, we're going to have a webinar on that topic. So we'll be sure to add this to make sure. But sitting here right now, I'm going to say no. That would not affect your status of changing trustee.
Yeah, that would surprise me at all. Just for what my thoughts. With that, it looks like we have gotten all through our pre-submitted questions, and we have no more questions that are coming through the chat feature. So we want to thank everybody for joining us today and spending a few time. We're looking forward to having you back for our webinars beginning next year. And with that, we wish everybody a happy and healthy holiday season. Thank you very much.